others and others required of themselves when it comes to the issue we are discussing today. And I totally concur with what they did. One thing that was said about the Iraqi Constitution was that perhaps Islam trumps what's in the Iraqi Constitution on Article 14. But I will suggest to you, based on the study that I have done of Islam, based on talking to women who come and talk to me directly in classes that I've had when we were studying the issue, I think that's a mixing of religion with custom. Because what the women who practice the religion themselves explained to us, to my surprise, that under the Islamic religion, women actually have more rights than we do in America. But custom is another issue. And oftentimes when we don't make that distinction, we will come to some conclusions that are not the proper conclusions of that religion itself. I think this committee has a unique opportunity today. When our forefathers set to write the Constitution, they didn't have to say it was for men. You know you have power when you don't even have to name who you are. Everybody understands it. It's those of us who were not recognized as the ones who have power who have to go back and ask to be recognized. And that's what we are doing today, asking to be recognized. Our forefathers did not have the foresight as brilliant as they were. They didn't have the foresight to do what you have the opportunity to do today. We've come a long way, and I look at the faces around this table, and it makes me feel proud to know that you can have more foresight than the men who put this Constitution together when they were not including everybody, did not intend to include everybody. I would think your intentions would be totally opposite of that. And what we're asking you to do is to include everybody. The Constitution does not pretend. It does not pretend to help men. It didn't have to pretend to help men. The Constitution is not a fraud. So to ask us to be included, women, in the Constitution is not a fraud. It means that 52% of the humanity of this country, because women are 52%, it means 52% of the humanity of this country basically has to come to this committee made up mostly of men to ask you to recognize us. That's how powerful it is to be a man in this country today. If it were a matter of numbers, we wouldn't even have to ask. I think somebody also mentioned earlier when Dean DePepper was talking about whether or not the courts would intervene when it comes to marriage at all. And he cited the Loving case. It's been my understanding about the Loving case, which had to do with interracial marriage. It's been my understanding the courts intervened there, and I'm not a lawyer. I'm just going on what I have been studying and what I've talked to people about in this case. That they intervened because under the 14th Amendment, when that 14th Amendment was written in regard to race, the Loving case was in regard to race. And I think it would be pretty a farce extrapolation to suggest that because the court intervened on the basis of race, which is the basis of the 14th Amendment, to say the same thing is going to happen if we indeed pass this resolution today. And I want to end with this, just a personal anecdote. When I was a student at SAU, and I was a student at Willisville High School, where I grew up in the country, and all we had for sports was basketball. We had great girls' basketball teams. And I was privileged to be on one of those great teams. I honestly thought, in my American mind, where we're all going to be treated equally, that I would be able to get a basketball scholarship just as the guys did. This was 1969. And much to my surprise, what I was told when I got to college was thinking about going, yeah, you can play on the basketball team. but there are not scholarships for girls. I was surprised by that. Well, I ended up not playing basketball because I would have to find my way to work and do everything else and practice when the guys were not using the gym. And I tell you that only to let you know what happened after that. Beginning my sophomore year, I began to work as a tutor. I was a tutor. And many of my clients, so to speak, were the boys who were on fully paid scholarships. I thought constitutionally that was wrong. I thought constitutionally I would not have been put in that position. And I say that to suggest to you it does matter what's in our permanent documents. It matters what's in our permanent documents. Because there are girls walking around today in 2005, and boys as well, who were thinking the same way I thought in 1969, that they were totally protected by the United States Constitution. Thought they were. We have an opportunity today to do something in the name of the Native Americans' philosophy, that what we do today matters 7 generations from now. We might be doing what we think is the right thing today, but what will happen to your children, your grandchildren? What will be the effects 7 generations from now if we don't put it on paper and say what we mean? And if we mean it, what's the problem with putting it on paper? What's the problem with your going home and saying to your children, your grandchildren, and to every woman in this room, we respect you enough to put it on paper? And I ask you to please do that. Thank you.
I'm Rose Mims, the Executive Director of Arkansas Right to Life. Thank you for your time and attention. I will be brief. I'm here today on behalf of the National Right to Life Committee and Arkansas Right to Life. We oppose HJR 1002 for 2 reasons. First and foremost, the sweeping language of the 1972 ERA would be used as a legal weapon against virtually all laws that regulate abortion. Indeed, ERAs with similar language have already been used successfully for this purpose in other states, including New Mexico. The New Mexico Supreme Court unanimously ruled that the state ERA, which contains nearly identical wording to the proposed federal ERA, required the state to fund Medicaid abortions. This lawsuit was brought by NARAL and supported in briefs by organizations such as the League of Women Voters, Planned Parenthood, and the ACLU, some of the same groups who are now trying to tell you that there is no connection between ERA and abortion. Amendment 68 of the Arkansas State Constitution that prohibits public funding of abortion, parental consent for minors' abortion, the Woman's Right to Know Act, and the Unborn Child Pain Awareness Prevention Act would all be at risk if the ERA is passed in Arkansas. Without abortion-neutral language added to the Equal Rights Amendment, any law restricting abortion in any way would be challenged as a violation of the Equal Rights Amendment. Secondly, the deadline for ratification of the 1972 ERA expired many years ago, and the U.S. Supreme Court flatly declared it dead in 1982. Even so, if 3 states adopt resolutions such as this, Congress would be forced to vote on whether to declare the 1972 ERA as ratified. I have provided to you a 2-page memo summarizing the case against it, both on grounds that it seeks to evade the amendment process required by the U.S. Constitution itself, and because the 1972 language does not contain safeguard language necessary to prevent its use as a powerful pro-abortion legal weapon. Many of you on this committee have sponsored and supported pro-life legislation that protects women and saves unborn children from abortion in Arkansas. If this passes in Arkansas, our laws will be challenged and will be at great risk. I urge you to vote against HJR 1002. Thank you.
We do have one question.